Ms. Mountford.
I try and pick up my pace a bit. I see I've got quite a lot to get through.
Yes.
But I was
We will restrain ourselves and let you crack on.
Of course not. That's the nature of this hearing, that I have to answer questions. I'm not trying to stop you. I'm just realising I ought to go a bit faster. But page 630 was Lord Hope explaining, having decided that this was civil for domestic purposes, why he also regarded these as criminal, ASBO proceedings as determination of a civil right, not a criminal charge for convention purposes. And in paragraph 71, he noted that the conduct which had to be demonstrated was not necessarily that was capable of being criminal. I will say that in relation to antisocial behaviour injunctions, it's very difficult to imagine behaviour being alleged, in relation to gangs injunctions, it's very difficult to imagine a behaviour which could satisfy the criteria, which would not also be a criminal charge. Then in paragraph 72, he spoke about the purpose of the legislation, not just depending on proof of conduct, but also only if it appeared that the order was necessary to protect people in the area, and that was after consultation. He said that was a strong indication these were not proceedings for a criminal charge, for determination of a criminal charge against the defendant. In paragraph 74, he noted that in contrast to proceedings for breach of the peace, there was no power of arrest under the Crime and Disorder Act 1998. That's obviously a distinction, because there is a power of arrest in relation both to gangs injunctions and antisocial behaviour injunctions, which puts this, I'm not suggesting this is determination of a criminal charge, but it's more criminal charge-like than an antisocial behaviour order in this context. And then in paragraph 75, the criterion about whether an antisocial behaviour order was a penalty, and he said it wasn't, because the essential characteristic was the defendant being prohibited from doing something, which in any event he would be, the purpose of the prohibition was to protect people, and the prohibitions were only those necessary for protecting persons from further antisocial conduct. And it's true there's no limits on the prohibitions apart from necessity. The defendants say this would banish the defendant from an area of the city where he lives or expose him to harsher penalties than he'd normally face if he committed an offence. But although an antisocial behaviour order, this is paragraph 76, may well restrict the freedom of the defendant to do what he wants, they are imposed for preventative reasons, not as punishment. And so, in paragraph 77, he concluded that this, the criteria for finding, the criteria for a finding under the 1998 Act did not have the character of criminal proceedings for the purposes of Article 6. The consequence of so holding is of fundamental importance to the future of this legislation, because cases such as, and he gave citations, illustrate the reluctance of the Strasbourg Court to accept that the use of hearsay evidence is compatible with the defendant's right under Article 6.3d to examine or have examined witnesses against him. So pausing there, my Lord, it's not that they say there must be a rule against the admission of hearsay, but the requirements that you can examine and have examined a case have that effect in practice. But he went on that he would hold that Article 6.3d doesn't apply, and that the rules of evidence that are to be applied are the civil evidence rules. That means that hearsay evidence, the use of which will be necessary in many cases if the magistrates are to be properly informed about the scale and nature of antisocial behaviour and the prohibitions that are needed for the protection of the public, is admissible. Then he considered the issue of whether they were civil proceedings to which Article 6.1 applied, noting that it was conceded in paragraph 78. He talks about that a bit in paragraph 79. There isn't a civil right to intimidate or abuse people, but Article 8 rights were engaged just below letter E, as were freedom of expression and freedom of assembly and association, and that section 1.6 applied no limits except as to what could be ordered, except they must be necessary, or prohibitions that could be imposed, except they must be necessary for the protection of people in the area, and those might infringe ordinary civil rights. And Then he said, although the jurisprudence of the Strasbourg court is as yet unclear on this point, I would hold that the fact that the prohibitions made under section 1.6 may have this effect is sufficient to attract the right to a fair trial, which is guaranteed in Article 6.1. This means that the court must act with scrupulous fairness at all stages of the proceedings when it is making its assessment of the facts and circumstances that have been put in evidence under the prohibitions, if any that are to be imposed. It must ensure that the defendant does not suffer any injustice. And my submission, my Lord, is that what Lord Hope then goes on to say about what justice requires must be read in that context. We have a duty to ensure that this is fair for Article 6.1 purposes. Just briefly, Lord Hutton, who's the only other... Sorry. I've skipped a vital bit. Paragraph 81 is the standard of proof. He cites Lord Phillips in the Court of Appeal, saying that antisocial behaviour orders have serious consequences. It was this point in mind that he commended the course which the Recorder of Manchester followed in the Crown Court, when he said that without intending to lay down any form of precedent, the court had decided to apply the standard of being satisfied so that they were sure. So pausing there, he said the Recorder of Manchester was right on the facts of that case to impose that standard, no precedent. Lord Hope said that he also would endorsed what the Recorder of Manchester said. He noted in paragraph 82 that counsel for the
When he
sections...
endorses what the Recorder says, is he also endorsing the intention not to lay down any form
Well,
of...
my Lord, I've looked at that, and I think not, because he goes on to say that he has already said he agrees with Lord Steyn, who says that there must be a rule, and then he goes... I would submit that he says that he endorses the approach, i.e. using the standard of being satisfied so that he is sure. And I'll come back to that in just a moment, if I may. Mr. Crowe, for the Secretary of State, said that his preferred position was that the standard should be the civil standard. This is the argument on civil standard, because he said, although it was a single inflexible test, the inherent probability or improbability was a matter to be taken into account. And he said, letter C, it was not an invariable rule that the lower standard of proof must be applied in civil proceedings. He maintained that this view was consistent with the position for which he contended that these were civil proceedings which should be decided according to the civil evidence rules. But, says Lord Hope, it is not an invariable rule that the lower standard of proof must be applied to civil proceedings. I think that there are good reasons, in the interests of fairness, for applying the higher standard when allegations are made of quasi or criminal or quasi-criminal conduct which, if proved, would have serious consequences for the person against whom they are made. This, as I've already mentioned, was the view which the Court of Session took in Constanda. Then just below letter D, there is now a substantial body of opinion that if the case for an order for such a banning order or a sex offender order is to be made out, account should be taken of the seriousness of the matters to be proved and the implications of proving them. It has also been recognised that if this is done, the civil standard of proof will, for all practical purposes, be indistinguishable from the criminal standard. And he cites B and Avon and Somerset, Constabulary and Gough. As Mr. Crowe pointed out, the condition of Section 11B of the Crime and Disorder Act, the condition that a prohibition order is necessary to protect people in the local government area from further antisocial acts, raises a question which is a matter for evaluation and assessment. That's the second condition. But the condition in Section 11A, that the defendant has acted in an antisocial manner, raises serious questions of fact. And the implications for him of proving that he has acted in this way are also serious. I would hold that the standard of proof that ought to be applied in these cases to allegations about the defendant's conduct is the criminal standard. Now, my Lord, looking at that and what Lord Hope said in paragraph 51 about agreeing with what Lord Steyn said and the reasons, and that Lord Steyn said in all cases, I would submit that he wasn't agreeing with that part of what the Recorder of Manchester said, that he wasn't laying down a precedent, because what Lord Steyn was saying was that to ensure consistency and predictability, that criminal standard was the one that should be applied in all cases. It was in effect indistinguishable from what was then perceived to be the higher standard, higher civil standard, and that is what fairness demanded. And just coming back to the point that Lord Reid raised with me this morning, it is of course true that there may be provisions in the civil law or indeed in statute which go beyond what the European Court of Human Rights would require of us, but if something is required as a matter of common law fairness, in my submission it is also required as a matter of Article 6 fairness. So you may say there's a provision, for example, the extent to which a jury trial is permitted, or the conditions in which a majority verdict is permitted, where one might say those are the rules, but they could be adjusted downward without doing violence to the overall fair trial. But if the conclusion is that you cannot have a fair trial without this happening, and that's, even if that's a finding on the basis of the common law, then in my submission it carries over and is what fairness requires for Article 6 purposes. And if I could take you to the case of Hammond, one paragraph in the case of Hammond on that, which is in Bundle 5.
We don't have bundles.
806, I'm sorry, that's for my Luddite colleagues like myself. For you, it's 2285, my lord.
2285.
So just wanted to understand, you say that if required as a matter of common law fairness, it's also required as a matter of Article 6 fairness?
Yes, there may be common law rules that go beyond what Article 6 requires, but if that's what you say, that is the bottom line about what fairness requires.
But I mean, isn't fairness an autonomous concept for the purposes of the ECHR?
Well,
In other words, something where the Strasbourg Court will lay down its own standards, irrespective of what any particular system of domestic law might provide.
Standards, but not the system for realising. That's what you have to decide, and this is what I wanted to take you to in Hammond.
So for example, if Parliament passed the Supreme Court Amendment Act 2023, which said that henceforth all appeals will be determined in writing, that would be overruling a common law principle that an oral hearing is afforded by courts in this country. You say that would an Act of Parliament be incompatible with Article 6?
Well, my lord, there are other contexts in which that common law rule has been overridden. For example, there are provisions that, although don't think they're ever used, but there are provisions that a judicial review could be determined on the papers. If it was an Osborne-like context where you couldn't properly challenge what was said in fairness, well then, no, that wouldn't be fair. It would breach the common law and Article 6. But if it were a change to what was understood to be the common law, but retained that basis of fairness, which it potentially might if there was, say, a written questions procedure, that would be different. Or if you reduced the size of the composition of the Supreme Court to 3.
That wouldn't affect fairness. That's simply...
Yeah. Well, one would have to decide if it did, but if you said that just can't operate fairly as a final court of appeal, then perhaps it might. It would depend on the circumstances. And my lord,
when juries were effectively removed from defamation cases, is that a breach of Article 6?
No, my lord, that's what I'm saying, that the decision has been you can still have a fair trial. So there are things that are aspects of the common law which can be attenuated without undermining the basic fairness. But if the reason you can't take something away, for example, the oral hearing in a parole board hearing, is because that procedure and the kinds of questions that need to be put in that procedure can't properly be put without an oral hearing, then that would be both a breach of common law fairness and Strasbourg fairness. And the point that, it's a well-made point, that Lord Sales has just put to me, which is that Strasbourg's not going to decide how you do that, is why that is a matter for this apex court. And if I could just take you to Hammond.
Just before we do that, I just was intrigued by the concept that if required as a matter of common law fairness, it is also required as a matter of Article 6 fairness. Doesn't that end up with the tail wagging the dog? Insofar as if we decide that as a matter of common law fairness, a criminal standard is required, that then would read across into all of Article 6?
It wouldn't say that it was a criminal charge, because that's an autonomous concept.
No,
how you apply the concept of fairness, yes, it would.
So rather than rights being brought home, rights are exported.
Yes.
No, my lord, they're not, because the common law might require more than you say is necessary as a flaw for a fair trial. But if you say the reason this is a common law requirement is because it is what is required in fairness, I don't say that what is required in fairness in the common law can be higher than what is required in fairness. There may be other reasons. It may be the better system or the more effective system, but there comes. It's like how much legal aid do you require in fairness? There's a floor below which you can't fall, but it doesn't mean legal aid is required for everything in all circumstances, or that it has to be at a certain level or anything of that kind. What I think this passage from Hammond might help with this, which is in paragraph 10. An article, Lord Bingham set out this is determination about release on licence for a lifer, my lord. And Lord Bingham set out the provisions of Article 10 at the top of page 2285. So the article guarantees a fair trial to a defendant on the determination of a criminal charge, or to a party whose civil rights and obligations are to be determined. This is a right which member states undertake to secure to everyone within their jurisdiction. The requirements particularised in Article 6.3 are standard conditions of a fair trial, but they are not in themselves absolute, while the overall fairness of a trial cannot be compromised. The constituent rights within Article 6 are susceptible to limited qualification in some circumstances. The European Court, for its part, assesses the fairness of proceedings in national jurisdictions retrospectively, since applicants are required to exhaust their national remedies before resorting to it, and the Court repeatedly asserts and follows the practice of making its assessment on an overall consideration of the national proceedings. And gives some examples, and then thus, this is below letter F, the Court will assess the overall fairness of the national proceedings viewed as a whole, but will not undertake the task before the House in this appeal of deciding whether a provision of national legislation is compatible with Article 6. And then there are authorities on that. However, this is the bottom of the page, as in Twilib and Greece, a specific feature is found to be a necessary condition of the fairness of a proceeding, and national law precludes fulfilment of that condition, a finding of violation will follow, and the inference must be drawn that the national law which precludes fulfilment of the condition is incompatible with Article 6. So if you find that fairness requires the application of the criminal standard and that the statutory provision precludes that, then we must say then that is a violation of Article 6.
Why is this not authority against you? Doesn't it show that Strasbourg treats the fairness standard as an autonomous concept, as I was putting to you?
Yes, but an autonomous concept for the national court to decide, not the legislature.
Well, there are 2 points being made here, as I understand it. One is, how does the Strasbourg court approach things? And Lord Bingham passes comment on that. And that's looking backwards, seeing everything that's been done and deciding for itself whether the proceedings have been conducted fairly. They don't look to see what national law of fairness is and say, well, national law of fairness was breached, therefore unfair. They're applying their own standard. And then the second point that he seems to be referring to is what happens in relation to an allegation of incompatibility of a particular statutory provision. So usually Strasbourg is looking back over what has happened on the particular facts of the case rather than judging the compatibility of a particular statutory provision. But Lord Bingham says, well, we, the National Court, have to do that. And in fact, there is some guidance from Strasbourg where they will do that as well.
Yes, but, so what I'm saying is, yes, so you have to decide if it's unfair, and if you take the view it's unfair...
But I would, forgive me for interrupting you, but I was pressing on the first of those points, which is Lord Bingham noting that the Strasbourg court applies its own standard of fairness. He doesn't suggest that there's a sort of, I don't know, a dance with the national legal system where Strasbourg says, well, if it's unfair according to national standards, we will treat it as unfair. Strasbourg just applies its own standard of fairness. Is that not right?
Yes, Strasbourg is a flaw standard, but I'm submitting that I'm submitting, and I must move on, but this is my submission, that if you find something is not fair, it's simply just not, can't give rise to a fair trial, a provision, then you are saying this doesn't meet that flaw standard. There are standards that might be required in national law that go beyond what is strictly required for that flaw standard of fairness. But I'm saying that what was determined in McCann, what we should be determining here, is what the flaw standard of fairness requires in all the circumstances, bearing in mind the seriousness, the arrest without warrant, the power of arrest without warrant, and so on and so on. That's the question.
The bottom of page 2285 refers to Twoile against Greece, and it says a specific feature is found to be a necessary condition of fairness of a proceeding. That is a specific feature in the autonomous concept of fairness, as administered by the European Court of Human Rights. You're interpreting it somewhat differently.
I'm saying that the previous part of the paragraph says the court is looking at the proceedings overall, but if, and I would interpret it in the context of the proceedings overall, a specific feature is required.
As a matter of the autonomous concept of fairness?
Yes. Yes. I say, were it necessary to go to Strasbourg, the Strasbourg court would say, bearing in mind how closely akin this is to a criminal charge, the fact that the kind of conduct that is to be proved, the seriousness of the consequences, the stigma, the fact that it can be backed by an arrest, and so on, and the fact that you can't use the Article 6.3 safeguards because you can't question all the evidence because hearsay is allowed. A necessary feature, an intrinsically necessary feature to get that floor level of fairness is that a high standard of proof is required, given that broad and in some circumstances unchallenged evidence which can be brought in.
Has the criminal law in relation to hearsay evidence changed since McCann? Has the criminal law in relation to hearsay evidence changed?
The criminal law?
Yes, in this jurisdiction, in England and Wales.
Yes, it has, my lord.
Yes. So the comments that are made about hearsay evidence in McCann are also out of date.
Yes, my lord, that's a good point, but they are still stricter than civil standards. But can I come back to you on that? Because they have changed, but if you ask me to give you chapter and verse, I'm going to look. Yeah. Yes. And then very, very briefly, in my last part of McCann is Lord Hutton, who held at 635, paragraph 88, that the reason that the remedy given by Section 1 had operated effectively was because the courts had held the proceedings to be civil, and therefore because hearsay evidence could be led on the civil standard. Not
88?
88, 635. So he's not saying and because you can use the civil standard of proof. It's the use of hearsay he regards as critical. Then in paragraph 112, moving forward, 642, at letter H, on the concept of a fair hearing in the determination of civil rights, it's on the assumption that these are civil rights, he says that a further question arises whether the admission of hearsay evidence constitutes a violation of their rights under Article 6, and he alone reserves the position on whether Article 6.1 is engaged. So everyone else says it is engaged. But at the top of page 643, He says that if it is engaged, he's of the opinion there's no unfairness in the admission of there is no unfairness in the admission of hearsay evidence by reference to striking a fair balance between the demands of the general interest of the community and the requirements of protecting civil rights, individual rights. The balance which is inherent in the whole convention, that's at letter E. So he says it's not fair when you look at how the right to a fair trial is applied here. Principles of a fair trial also require, letter F, that in appropriate cases the interests of the defence are balanced against those of witnesses or victims called upon to testify. And that he cites Dawson, but of course there's also the Rape Shield case in the domestic context. And it's against that background that he goes on to say, in paragraph 114, that he agrees both with Lord Steyn and Lord Hope that in proceedings under Section 1, the standard of proof that ought to be applied about past behaviour is the criminal standard. So he's been talking about the fair balance that's inherent in the search for what is a fair trial for Article 6 standards. And it's in that context that he agrees with Lord Steyn and Lord Hope. And then Lord Hobhouse and Lord Scott also agreed with all three. So that is how the law stood when the provisions we fall to consider in this case came into force. Now, the issue in what Lord Steyn called this corner of the law, so this corner of the law, which is seeking to protect the community from antisocial behaviour where there may be inhibitions on people giving oral evidence to protect the rule of law and the right of the community to live free from fear and violence. So in Shafi, the issue was whether the local authority could, as it were, get around the specific statutory provisions which governed applications for ASBOs by applying instead under Section 222 of the Local Government Act, which empowers local authorities to bring proceedings in their own name where they consider it expedient for the promotion or protection of inhabitants of their own area. And this really was an application for a proto-gang injunction. You can see this at page 671. Part of Shafi, that in the head note, Birmingham City Council sought injunctions to restrain defendants who are alleged gang members from entering the city centre, associating with named individuals or wearing green, which was the gang's colour. And the injunctions sought were said to be identical or almost identical to ASBOs, and indeed ASBOs were sought for those who were under the age of 18. I'm just going to summarise here. The judge held no jurisdiction to consider these injunctions. He also held, the trial judge, he couldn't be sure that either defendant had participated in acts which were criminal or amounted to public nuisance, and he also held it wasn't necessary or appropriate to make orders, so he discharged interim injunctions and dismissed the claims. And on the local authority's appeal, a majority of the Court of Appeal held that Section 222 was a procedural power which extended to the local authority the power only previously available to the Attorney General at common law to bring and defend proceedings in support of public rights, but said that that was subject to legislation specifically designed to deal with a situation for which the injunction was sought. And since the Crime and Disorder Act 1998 was a detailed statutory scheme, it was wrong in principle for the local authority to bring applications for injunction akin to an ASBO under Section 222, except in an exceptional case, but that if the High Court or the County Court did consider such an application, did find it necessary to consider such an application exceptionally, then it should do so on the basis of the criminal standard of proof, because that is what the House of Lords had held fairness demanded in this corner of the law in McCann. And he then considered paragraph 48 on page 689, how this applied in the light of McCann, and whether this had been altered by the then recent decision of the House of Lords in VB Children.
Sorry, paragraph
48.
Thank you.
About the flexible standard of proof. So that's the point that's made here. The law on the civil standard of proof has moved on since McCann was decided. And in paragraph 48, he quoted Lord Steyn at paragraph 37 about the approach that should ensure consistency and predictability in this area of the law. And then at paragraph 49, said that the whole topic of the standard of proof in civil cases has recently been revisited by the House of Lords in Re D and in Re B Children, but it wasn't suggested by counsel in this appeal that the reasoning in those cases affects the decision of the House of Lords in McCann's case. We agree that it does not, with the result that the decision in McCann's case governs the position in ASBO proceedings. It follows that if these orders had been sought from a magistrate's court as ASBO's, the court would have been sure that in each case MS or TE had acted in the way alleged, and if it was sure, would then have had to decide whether the order was necessary. The judge approached the standard of proof in that way and concluded that he couldn't be sure on the evidence in either case. And then, just above letter C, it's submitted on behalf of the counsel that he was wrong to approach the standard of proof in that way in the context of an application for an injunction as opposed to an ASBO. It would, in our opinion, be startling if it was so. In the passage quoted above, Lord Steyn said that the approach to the standard of proof which he identified should facilitate correct decision-making and should ensure consistency and predictability in this corner of the law. By this corner of the law, he was, as we see it, referring to orders restraining antisocial behaviour of the kind that can be restrained by an ASBO. He wasn't intending to apply the criminal standard of proof to other types of injunction, whether in aid of the criminal law or to restrain public nuisance or otherwise. And we say that Re D and Re B are cases in very different contexts. One's about the standard of proof for facts used in deciding to recall a prisoner on licence, and the other is about child protection. And we say, indeed, what's said in those cases about the limits to this flexible standard of proof, civil standard of proof, actually reinforces what was said in McCann, that you need to apply the criminal standard to get the appropriate level of scrutiny of evidence for fairness, because you can't do it on a case-by-case basis, applying the civil standard of proof more or less flexibly depending on the seriousness of the allegations or the seriousness of the consequences of them.
Still don't understand what the seriousness of the consequences has to do.
It doesn't.
It
doesn't, my lord. That's what I'm saying. And so the courts in Re D and Re B Children were right to correct what, as my lady Rose has said, is an illogicality in bringing into the likelihood or otherwise of something having happened, the standard of the level of evidence required to establish its probability. If you're saying that the seriousness of the allegations and the consequences mean that particularly rigorous scrutiny is fair, you need to do that by saying that a higher standard of proof should be applied in the interests of fairness. And that is what, in my submission, McCann did. And in my submission, that standard of proof is what fairness requires here because of the context in this corner of the law.
So you disagree with what Lord Kerr said at paragraph 134 at page 919 as to significant consequences?
Sorry, which paragraph?
134, page 919.
Yes, my lord, the last sentence in my submission is not a correct summary of the law after Re B or Re D. In Re D, if I can just take you very briefly to Re D and Re B. Re D starts on page, or the relevant passage starts on page 2455. It's about the
I missed the page number, sorry.
2455, my lord.
Thank you very much.
And this was a case about establishing facts which could justify recall of a lifer on licence. And at 2455, letter H, just below letter G, the Court of Appeal had held that the panel had applied the wrong standard of proof and recognised that there's a single civil standard of proof, but that it should be applied, that said that it should have been applied flexibly in the circumstances because either of the seriousness of the allegations or because what was alleged was inherently unlikely. And paragraph 18, the Court of Appeal said that the need to look for compelling evidence to discharge the burden of proof is not confined to the situation where it can be said that the commission of offences is inherently unlikely. And Lord Hoffman then went on in paragraph 25 to say that was wrong and unfortunate. The phrase he's
Lord Carswell, I think.
Sorry, I'm not sorry. It's yes, I'm sorry. It's Lord Carswell at this stage. Yes. Sorry, Lord Carswell cited Lord Nichols in re H about the degree of probability, and then he cited in paragraph 26 Lord Hoffman in the decision of Raymond, where the SIAC had held that the Secretary of State hadn't established to a high degree of probability that an applicant was likely to be a threat to national security. The House of Lords held that where past acts were relied on, they should be proved to the civil standard of proof, and Lord Hoffman said, I turn next to the Commission's views on the standard of proof. By way of preliminary, I feel bound to say that I think the high civil balance of probabilities is an unfortunate mixed metaphor. The civil standard of proof always means more likely than not. The only higher degree of probability required by the law is the criminal standard. And then he went on to say that Lord Hoffman had recently turned to the topic in Re B, where, with support of Baroness Hale, he reaffirmed in emphatic terms the views which he expressed in Raymond. I'll come to Re B in a moment, but it seems that Re B was handed down on the same day. So he must have had some foresight of it. They both handed down on the 11th of June. Lord Brown then explained why he thought this was an important point of principle at paragraph 40. And he said that he wanted to elaborate one aspect of Lord Carswell's opinion. This is page 2462. I want to indicate certain concerns I have about the much discussed, some would say greatly overanalyzed question as to how tribunals should approach cases involving the civil standard of proof. I am troubled by one or two of the recent authorities. There really seems to me an issue of principle at stake here. And then in paragraph 43, in paragraph 41, he talked about the unquestionably useful and accurate statement of the position in Raymond, and the well-known statement that where something's intrinsically unlikely, more evidence is required to satisfy the civil standard of proof. It would need more cogent evidence to satisfy one that a creature seen walking in Regent's Park was a lioness than to be satisfied to the same standard of probabilities that it was an Alsatian. On this basis, cogent evidence is generally required to satisfy a civil tribunal that a person has been fraudulent or behaved in some other reprehensible manner. But the question is also whether the tribunal thinks it's more probable than not. And in paragraph 43, obviously everything going to the likelihood or otherwise of an allegation being true or an offence having been committed or other reprehensible conduct is relevant to the court's consideration of whether, having regard to all the evidence, it's been established as more likely than not. And generally speaking, as Lord Nichols was pointing out, people tend not to commit serious offences, not least because of the consequences that are likely to follow if they do. and that somebody at the bottom of that paragraph, somebody with good character is less likely to behave badly than somebody with bad character. Somebody who values their reputation will be less likely to imperil it, etc. But paragraph 44, it is surely equally obvious that the more inherently unlikely it is that something has happened, that an allegation is true, the more persuasive or cogent the tribunal will need to find the evidence pointing that way before concluding it to be more likely than not. And on this, I share the views expressed by Lord Carswell. My difficulty comes at the point when certain of the authorities speak of requiring stronger than usual evidence to prove the case on the balance of probabilities, not to overcome any inherent improbabilities in the case, but rather because to find it established would have serious consequences for the person against whom the allegation is made. This is Lady Rose's point. And he cites a submission on that and says, in paragraph 46, for my part, I would have rejected, not accepted, counsel's submission. If the evidence satisfies a tribunal charged with deciding questions on the balance of probabilities and that an allegation is more likely than not to be true, notwithstanding whatever unlikelihood there may be in A, having acted as alleged, given the serious adverse consequences to him of likely to result from so acting, then in my judgment it would be quite wrong for that tribunal to decide the question in A's favour merely to save him from the serious consequences of a finding against him. For example, to save a bank manager from a finding of dishonesty. I do not for a moment suggest that the serious adverse consequences of a decision are for all purposes, other, of course, than insofar as they point to the probabilities, irrelevant. But their relevance goes to the standard of proof to be applied in the first place. It is because of the serious consequences of criminal convictions or adverse disciplinary findings that the criminal standard of proof beyond reasonable doubt, is required in those cases. And then he goes to some passages in other cases where he says they're not easily reconcilable, and he includes in that long list of passages, just below the letter F, what was said in McCann. And he cites, just at the very bottom of that page, pragmatism dictates the task of magistrates should be made more straightforward by ruling they must in all cases apply the criminal standard, Lord Steyne in McCann. Views precisely echoed by Lord Hope of Crayhead in the same case. And then he said, I question whether it would not have been more logical and appropriate to have decided that the making of the various orders calls for the criminal standard of proof to be satisfied in the first place. Certainly once it became established that there is no such thing as an intermediate standard of proof, logic surely demands that one standard or the other be applied, and common sense dictates the rest. And I agree with that, but my lord and my lady, what I submit is that is, in fact, what it would be the logical and appropriate course, and fairly read, it is the course they took. Lord Steyne was saying at paragraph 29, even a civil defendant has the benefit of a guarantee of a fair trial. And then in paragraph 37, accepting that there is little difference between a heightened civil standard and a criminal one, pragmatism dictates that to ensure consistency and predictability in this area of the law, that the House should hold that they must, in all cases, apply, under Section 1 of the 1998 Act, apply the criminal standard. And I say that that is precisely what the court in McCann was doing. They were doing what Lord Brown said they should do, take the inherent seriousness of the findings of the consequences, and in the context of all the other provisions of the legislation which they were applying in that area of the law, which they had analysed closely, deciding that these combined to make the criminal standard of proof the fair one to apply in all cases in that corner of the law.
I would question paragraph 48, where it suggests that serious consequences of adverse disciplinary findings requires the criminal standard of proof. That would lead to the consequence, for instance, that a school teacher who's probably a paedophile would avoid adverse consequences, because you couldn't establish that he was certainly, or beyond all reasonable doubt, a paedophile.
Yes, my lord, I think that might be right, and it would depend on the type of criminal type of proceedings. But in that case, it would be because the purpose of those proceedings was protected. So it would be a bit like the Reby children case that I now want to take you to, that the whole context of what was being decided and whose rights were being protected would lead to a different balance of fairness having regard to the seriousness of the findings, because the findings wouldn't be to stop the teacher doing things or to make him go to wear a tag or to have a curfew. It would be to protect the child from or other children from potential future wrongdoing. I mean, we're creating a hypothetical scheme. You're right, my lord, that Lord Brown there sort of sets something up without examining the parameters of it. But what I'm saying is that he was right to say that in this corner of the law, the judges in McCann had to look at what fairness demanded, and if they concluded that it required a heightened level of scrutiny of the evidence, bearing in mind that much of that evidence would be hearsay, anonymous, and so on, then the fairness required that that be subjected to a higher standard of proof, and the court should have said, and in my submission did say what Lord Brown says they should have said, that if that's what fairness requires because of the consequences, then they should say that, because you can't think the logic about what probability requires in order to achieve that circumstance. You have to say that that's what the underpinning standard of fairness requires, given all the other aspects of that scheme. But I don't want to be drawn into how far that would go into other schemes, hypothetical schemes, which are not before us, because the application of that principle does vary from context to context. My submission is simply that gangs injunctions, which were effectively the gangs allegations, which were effectively what was alleged in Shafi, or antisocial behaviour, are sufficiently similar to the corner of the law examined in McCann that the principles in McCann apply over to that. But I don't want to take it further and make some overarching submission, and I don't make an overarching submission, that no matter what the context or what the proceedings or what they're determining or for what purposes, if the allegations are serious ones or have serious consequences, the criminal standard must necessarily be applied. The application of that principle in each framework is for the court. And you see that from Re B, which is the other House of Lords decision, which clarified the standard of proof, handed it down on the same day as Re D, although in a very different context, with a different House of Lords. Lord Scott was the only crossover judge who was in both. And in that case, it clarified the distinction between deciding which standard of proof should be applied and how, clarified the distinction between deciding which standard of proof should be applied and how, if it was going to be the ordinary civil standard, it should be applied. They dealt more directly and less compendiously than Lord Brown had done with the decision in McCann. And the issue in the B children was not the protection of the public at large, or the making of any kind of injunction or order about what anyone must or must not do. The question was the standard of proof which should have been applied for establishing whether the threshold criteria for making a care order in relation to a specific child or children were satisfied under Section 31(2) of the Children Act 1989. And you see that at page 698 at letter E. I'm sorry, 698 letter E is the head note and contains the context of the case, which I've just summarised, but the criteria which were being applied are on page 709 in paragraph 22. The principle of an unacceptable risk of harm is easy to state but difficult to put into statutory language. And it ultimately resulted in Section 31(2) of the Children Act 1989, just below letter E. A court may only make a care order or a supervision order if it is satisfied, A, that the child concerned is suffering or is likely to suffer significant harm, and B, that the harm or likelihood of harm is attributable to the care is given to the child or likely to be given to him if the order isn't made, not being what it would be reasonable to expect a parent to give him, or the child being beyond parental control. And the case, to G, is about the meaning of the words is likely to suffer significant harm. How is the court to be satisfied of such likelihood? This is prediction from existing facts, often a multitude of such facts, about what has happened in the past, about the character and personalities of the people involved, about the things which they have said and done, and so on. But do these facts have to be proved in the usual way? Or is it sufficient that there's a real possibility that they took place, even if the judge is unable to say that it's more likely than not? She says that this was authoritatively determined in favour of the former solution, and so the situation is either those facts occurred or they did not occur. And the holding was that the civil standard should be applied because this starts on paragraph 62 on page 719, the discussion of the standard of proof. She, in paragraph 62, explains Lord Nichols' speech in Re H and how it was misunderstood. And then in paragraph 66 cites what Lord Steyne said about that in McCann, and says the House went on to hold that in antisocial behaviour order proceedings the court should apply the criminal standard of proof. And the link with in Re H having been made, it's not surprising that judges should sometimes think that the same heightened standard should also apply in care proceedings. But then in paragraph 68, she said that fortunately for care proceedings, that misunderstanding was corrected and status quo restored by the President of the Family Division, Dame Elizabeth Butler-Schloss. And she said, just below letter D, that the standard of proof to be applied in the Children Act case is the balance of probabilities and the approach to these difficult cases laid down by Lord Nichols in Re H. That test hasn't been varied or adjusted by Lord Bingham or by Lord Steyne and McCann, who were dealing with applications made under a different statute. There would appear to be no good reason to leap across the division on the one hand between crime and preventative measures taken to restrain defendants for the benefit of the community, and on the other, wholly different considerations of child protection and welfare. My Lords, I entirely agree. There are some proceedings, though civil in form, whose nature is such that it is appropriate to apply the criminal standard of proof. Divorce proceedings in the olden days may have been one example, but care proceedings are not of that nature. They are not there to punish or to deter anyone. The consequences of breaking a care order are not penal. Care proceedings are there to protect a child from harm, and the consequences for the child of getting it wrong are equally serious either way. And then, irrespective of the, and I say that's irrespective of the seriousness of the allegations or consequences. And then Lord Hoffman, if I go back to Lord Hoffman, I'm sorry, at page 704, started off by saying he agreed with Baroness Hale. In paragraph 2, he said that something had either happened or it hadn't happened, and that the ordinary civil standard should be applied at paragraph 4. And then in paragraph 5, he said there'd been some confusion caused by dicta which suggested the standard of proof may vary with the gravity of the misconduct alleged or even the seriousness of the consequences. The cases in which such statements have been made fall into 3 categories. First, the cases in which the court has, for one purpose, classified the proceedings as civil, for example, for the purposes of Article 6, but nevertheless thought that because of the serious consequences of the proceedings, the criminal standard of proof or something like it should be applied. Secondly, there are cases in which it's been observed that when some event is inherently improbable, strong evidence may be needed to persuade a tribunal that it's more probable than not. And thirdly, there are cases in which the judges are simply confused. He then put into the first category in paragraph 8 the case of B and Avon and Somerset, and then said that there was a similar where Lord Bingham had said the civil standard of proof does not invariably mean a bare balance of probability and doesn't mean that in the present case. It's a flexible standard, so citing that flex. And then a similar point arose in McCann, this is paragraph 9, concerning an antisocial behaviour order. The court held that the proceedings were civil for the purposes of Article 6, but then he cited Lord Steyn in paragraph 37. And then he in paragraph 12 on page 707, he too cited the passage in the speech of Lady Dame Elizabeth Butler-Schloss. In fact, just by letter G, he went a little bit further in his citation and cited the observation that the rules of evidence in a criminal trial, which are contrasted with the partly inquisitorial approach the court is taking dealing with children cases, and that Lord Nichols' observations should be applied in the family proceedings. He then invited the House fully to approve these observations. I think the time has come to say once and for all there is only one civil standard of proof, and that is proof that the fact in issue has more probably occurred than not. And then this: I do not intend to disapprove any of the cases in which what I've got in what I have called the first category, but I agree with the observation of Lord Steyn in McCann that clarity would be greatly enhanced if the court simply said simply that although the proceedings were civil, the nature of the particular issue involved made it appropriate to rely on the criminal standard. So he's not disapproving McCann.
Well, he's not disagreeing with the outcome, but the first sentence of paragraph 12, he's citing it as exemplifying confusion. The degree of confusion is exemplified by the fact that, although you can read on.
Sorry, my Lord, I've just lost my place.
It's 707.
Thank you, my Lord. Yes, so he's criticising Lord Steyn using Lord Nichols to describe a heightened civil standard, but then he's saying there's one civil standard, and I agree with Lord Steyn at the bottom of the page that clarity would be enhanced if the court simply said that there are some circumstances where it's appropriate to apply the criminal standard, and that is what Lord Steyn was saying. Perhaps not with exemplary clarity, but he was saying, the recorder said effectively the criminal standard should be applied. I agree with him. It's hard for magistrates to apply this heightened civil standard. It's better for the House just to say apply a criminal standard, because that's fair when you're balancing it against the use of hearsay and so on, which is necessary and justified because these are civil proceedings. But it's appropriate to balance that against the use of the criminal standard.
Yeah.
So I submit that's what...
Just another bit in paragraph 15 when he says there's only one rule of law and the rest is common sense.
Yes, which I would use, my Lord, to deprecate the suggestion that because Lord Steyn talked about pragmatism, he meant he was being unprincipled. I say that he was saying, how do you ensure that this standard, which is the fair standard, is applied in these circumstances? It would be best for the House to say it applies in all ASBO cases. And this corner of the law would then be clarified and the law would be more predictable and consistent.
Yes, so even if the only prohibitions that the Crown was seeking in a particular ASBO order were limited, you would still always apply the criminal standard, just as a matter of consistency, rather than say, well, they're not asking for anything terribly intrusive in this case, so I'll apply a civil standard here, whereas here they are asking for a ban on him going into Birmingham and doing things.
Yes, my lady.
Instead of having that kind of scale, they're saying, regardless of the seriousness or otherwise, in this particular case of the injunction
Yes.
being sought,
Yeah.
it's always going to be the criminal.
Exactly, my lady. And I think what Lord Steyn was envisaging, given his understanding of Re-H, was, well, heightened standard. How heightened is heightened? It's just complicated to try and decide precisely that. How serious is this case? It's better to say if you ought to apply a heightened civil standard, effectively indistinguishable from a criminal standard in fairness, bearing in mind you can use hearsay to get to that standard, and he specifically says you can get to that standard on compelling enough hearsay, but you do need to make sure it's compelling enough, because otherwise you've tipped the balance too far the other way and you're not ensuring the fundamentals of the fair trial.
Ms. Mountfield, I'm a little confused as to how this line of authority fits in with your submissions. Can you help me?
My Lord, the Respondent and the Secretary of State say that McCann is undermined by the fact that the law has moved on in relation to the civil standard of proof. I say, if anything, this strengthens what I say, because fairness cannot be achieved by application of a heightened standard of proof, a civil standard of proof in an appropriate case. If it is true that a standard akin to the criminal standard is required to achieve fairness, then the court ought to say that a rule that says the civil standard applies is inherently unfair, because it precludes that standard being applied. You can't flex the civil standard enough just because these are serious circumstances.
So you say there's no via media left, therefore it has to be criminal standard?
Yes, and that not only do those observations following McCann not undermine it, they actually strengthen the logic of what Lord Steyn said needed to be done as a matter of pragmatism. And I say to achieve a fair trial. If you read his judgment fairly, that's what he's trying to achieve.
But, I mean, might it not be said that Lord Hoffman is not making the comments he does, particularly about the first category of case he mentions in paragraph 5, by reference to what the requirements of Article 6.1 and a fair trial are? It seems clear that he's talking in terms of how domestic law operates, because he's gone back to old cases like Beta and Beta and so on, which are obviously not to do with Article 6.1, but how common law domestic standards can be applied in relation to working out what, as a matter of domestic law, we might say is the standard of proof to be applied.
Well, my Lord, he's looking at what fairness demands in those circumstances. Yes, I mean, if my Lord, you are to say that the standard of fairness here has nothing to do with Article 6.1, only to do with the common law, then you would also say that even if you think this is unfair as a matter of common law, there's nothing you can do about it because the statute is clear. But my submission is that if you find that a criminal standard of proof ought to be applied to cases in this corner of the law in the interests of fairness, then that permits you to say that there is a breach of the floor standard in Article 6.1 and Section 4 of the Human Rights Act can be applied. Can I then move on to the issue here, which is whether there is anything in the purpose, context or structure of the gang injunction provisions under the Policing and Crime Act 2009 or the antisocial behaviour injunction provisions of the 2014 Act, which mean that notwithstanding the decision in McCann, there is some lesser standard of fairness which can be applied in this context without underpinning the fair trial guarantee. And that is, of course, because the language of both statutes, unlike the language of the 1998 Act, explicitly states that the civil standard should be applied. So the question is whether Parliament, and by explicitly stating that, has violated Article 6 standards. And the fairness, or otherwise, must be derived from the language of the Acts themselves. And I'll take each statute separately. The Policing and Crime Act is in the first bundle of authorities, starts at page 474. And I will take this briefly because we all set it out in our written cases. But this provision, section 34, says that a court may grant an injunction against a respondent over 14, so that's older than an ASBO. ASBOs could be sought for those of 10 or under, 10 or over. And then if the court, the two conditions, if the court is satisfied on the balance of probabilities that the respondent has engaged in or encouraged or assisted gang-related violence or gang-related drug-dealing activity, and that includes threats of violence, which you can see over the page at page 34 subsection 6. So that's the first condition. And the court thinks it's necessary to grant the injunction for either of both of two purposes. The first is to prevent the respondent from doing those prohibited things, or to protect the respondent from gang-related violence or gang-related drug dealing activity. Then the court may make an injunction under section 34(4), which for either or both of those purposes prohibits the respondent from doing anything described in the injunction, or requires the respondent to do anything described in the injunction. So the requires the respondent to do anything goes beyond what was in an ASBO. Under section 34(5) defines what is gang-related, and section 36. Sorry. And just. Sorry. So then section 35 sets out some of the prohibitions which can be contained in the injunction, and some of the requirements which can be imposed, which include curfews and participating in mandatory activities. And my lords and my lady, I won't turn it up now, but if in the supplementary bundle you were to glance at the provisions of section 177 of the Criminal Justice Act 2003, which is on page 89 of the Criminal Justice Act, you will see that they bear a remarkable similarity to the provisions which can be made under a community order in relation to a person who's aged 16 or over who is convicted of an offence: programme requirements, activity requirements, curfew requirements, exclusion requirements, and so on. So very significant mandatory requirements which can be imposed by an order, a gang-related injunction. Section 36, page 478, says that these injunctions can last for up to 2 years. That's less than an ASBO. An ASBO was up to 5 years. And it may be reviewed, as an ASBO was able to be reviewed. And page 478, subsection 6, sorry, 479, subsection 6, the court may attach a power of arrest in relation to prohibitions in the injunction or requirements other than those which require participation in activities. So unlike an ASBO, there is a power of arrest. Section 36,
sorry?
Section 36(6) on page 479.
36(6), I have it, thank you.
Section 37 sets out who can apply for such an injunction: chiefs of police, British Transport Police, Chief Constable of British Transport Police, or a local authority. Section 38 sets out some provisions about which other bodies should be consulted by applicants for an injunction before one is made, but there are exceptions to that. Section 39 on page 483 provides that an application can be made without notice, and without notice, paragraph 39(3), it can be made without consultation, because section 38(1) doesn't apply. So just pausing there, remembering in this case there was an without notice interim injunction which was in force for a very long time before the 2-year injunction was applied. So that's not without teeth, that disapplication of the notice provision. The provision for interim injunctions is in section 40, page 484. An interim injunction can be made, subsection 2, if the court thinks it's just and convenient to do so, and subsection 3, so section 40, subsection 3, an interim injunction can include any provision which the court has power to include in an ordinary injunction granted under 34, including the power of arrest. So an interim injunction without notice can be made which imposes activity requirements, and it can also include a power of arrest, though not in relation to failure to perform the activity requirements. Section 42 is the power to vary or discharge an injunction, and I note that section 42, subsection 3 on page 486 includes the power to vary an injunction to include additional prohibitions or requirements, or to extend the period for which a prohibition or requirement has effect, or to attach a power of arrest. So that's unlike an ASBO 2, that within the scope of an order, an application for variation can include a variation upward.
Yeah, you omitted, I think, section 41. That does give greater protection where an application is made without notice and an interim injunction is granted.
Yes.
I mean, if notice has been given, the test is just and convenient. If it's not been given, the test is necessary.
Yes,
and
can't have requirement of participation.
Yeah.
Sorry, my lord, I think I misstated that one.
Yeah.
Yes. Yes, all other provisions under section 34 can be included, including the power of arrest. I'm sorry. So section 42 is application for variation or discharge, and section 42, subsection 3486, is variation upward, including to extend to a power of arrest. And where there is a power of arrest, then section 43 on page 488, and that arrest can be without a warrant. And one can be held in custody for up to 24 hours, although if the arrest is on a Friday night, which is Christmas Eve, I calculate it would be up to 72, so there are some exceptions, but in general it's 24 hours that someone can be arrested and held before being brought in front of a judge. The penalty for breach, and the general penalty for breach, my lord, is just because this is a civil injunction, civil contempt proceedings, which obviously have to be proved to a criminal standard and can lead to up to 2 years in prison or a maximum fine. But for children, section 46A on page 493 and schedule 5A, pages 507 to 538, provide a separate regime, and in short, if a child breaches an injunction, then the matter goes to a youth court, and a number of sanctions can be imposed, including a supervision order or a detention order. I've taken that rather quickly. They are summarised in a table, a comparative table, which I think was circulated to the court on Thursday or Friday, which was intended to show by characteristic the distinction between the various powers. I'm not sure it's as helpful as it could have been because it went on for too long, but those provisions and where the paragraphs are in that table. So that's a whistle-stop tour through the provisions.
Notice that section 50...
Sorry, my lady. Section 50.
Originally provided for a review after 3 years. And I think there is a review document exhibited to Mr. Hunt's witness statement, which refers to perceived difficulties with getting evidence together in support of injunctions.
Yes, my lady. Yes.
I don't think there's been a review since. That was in 2014, I think.
Yes, that was... My lady, can I come back to that? I'm just conscious of the time. I've taken slightly whistles. I'll come back to it and reply to anything Broadfoot says on that. Yes, I mean, there is a review of the operation of the Act, which has to be undertaken and which was undertaken. That was the whistle-stop tour, but the similarities and differences between this and an ASBO are as follows, and I submit that they are insufficient to justify departing from what the House of Lords in McCann said was necessary for fairness in this area of the law. Firstly, like an ASBO, a gang injunction is also a civil order aimed at enforcing the criminal law and upholding public confidence in the rule of law in some urban areas where groups of people cause fear, distress and misery, and where fear of reprisals makes victims reluctant to report. And that is the aim of an ASBO, as Lord Steyn observed in paragraph 16 of McCann, page 613. It's also, because it's a civil order, a context where hearsay evidence and anonymous evidence may be used, so the person who's subject to an order can't always question the motives or potential mistakenness of an individual. So one might say Ms. X gave evidence. You can't tell the respondent who that is because she's frightened of reprisals and gangs in the area. So he can't say, but Ms. X is the mother of so and so who has a grudge against me. So it's also a context where that is the case, and we accept clarity that is, in the light of the decision in McCann, fair, balancing the rights against people against whom such an order is sought with the rights of people who may be witnesses but frightened, the public as a whole, to have the rule of law upheld. But it is a tilt of the scales towards the general public interest, and it was in that context, exactly that context and area of the law, that the House of Lords in McCann felt that the criminal standard of proof needed in all cases to be applied to proving the index facts to keep the scales even, which is a fundamental aspect of Article 6.1, bearing in mind that that standard, that beyond reasonable doubt standard, could well be met on hearsay evidence alone if that was sufficiently robust. So that's the nature of the order. The purposes for which a gang injunction could be sought are wider than the purposes of an ASBO. As well as protecting the public, there is also the potential objective of protecting the respondent himself from gang-related violence or drug dealing. Now that is a very unusual power and, at least in relation to an adult, a very serious infringement of autonomy. One thinks of Constander and Essen Miller. Those are cases where orders will be put in place for protection of a child, and even then criminal facts which justified that need to be proved to a civil standard. I can't think of another context where something is applied, an adult of full capacity who has not been convicted of any offence can be forced to undertake some activities which he doesn't want to undertake for his own good, or to wear a tag, or to be excluded from speaking to people or from an area, and is told, this is a compulsory order for your own good, and if you don't comply with it, you might be in contempt of court and you might go to prison. In the case of James, I'm not going to take you to it in view of the time, but the reference is 2544, paragraph 15. It was a Court of Appeal case about a gang injunction. Lord Justice Moore-Bick said it was difficult to imagine circumstances where a court might grant an injunction for this sole purpose, because inevitably the findings of fact would have to be about gang-related violence or drug dealing by the defendant. So he thought it was unlikely that that would be the sole purpose of such an injunction. But that, in my submission, makes it more, not less necessary that these are fair proceedings, because when a person's liberty is being restricted in a way which they do not wish it to be restricted, and without a justification based on the need to protect others, it is potentially even more important to apply the criminal standard of proof. This is without precedent, and it's also not telling people they can't do things which would be banned in any event because of the criminal law. It's saying you're banned from doing things which most adults would be expected to be able to do, like phone whoever they want, email whoever they want, meet whoever they want, and walk around their local area. The next point is that the behaviour which has to be proved in relation to a gang injunction as a first condition is, in my submission, virtually certain to be identical to the factual elements of a criminal offence. Lord Justice Moore-Bick, again in James, at page 2543 of the electronic bundle, said that the facts which failed to be proved for the making of an antisocial behaviour order were less serious than the facts which failed to be proved for the making of a gang injunction. And I make the point that violence or threats of violence are criminal offences because they are assaults. So is drug dealing. My written case sets out the statutes that make that a criminal offence. Engagement in those things can't just mean being a present or going along. We do have in the additional bundle, we put it in last night, the Supreme Court's decision in Jogi, I'm not sure how you pronounce it, but which establishes for the purposes of joint enterprise that simply going along with someone who is committing a criminal offence isn't enough to make something a joint enterprise. There has to be some state of mind, and I'll perhaps come back to it, but the suggestion that if you happen to be going along with someone who is drug dealing or in their presence, you are engaging in it, I submit that can't be the case. Otherwise, if you gave a child or a grandchild a lift to school and it turned out that they had drugs with them, you'd be engaging in drug dealing, even if you knew nothing about it.
I'm sorry, I missed more the page reference to Justice Aldbeck's.
2543, my lord. He says that the elements of an ASBO are less serious than the elements of a gang injunction. And encouraging or assisting in those acts, violence or drug dealing, are also both now a crime under the Serious Crime Act 2007. And for your reference, those are in the supplementary bundle at pages 37 through to 40. That's the provisions of Archbold, and the statutory provisions themselves are 86 to 88.
Can you just give those page numbers again?
Yes, this is the supplementary bundle, yes. 37 to 40.
37 to 40?
Yes, and 86 to 88.
What about mens rea? Is that required under 34.2?
Yes, my lord, it is.
Under you say under section 34.2?
Yes, for assisting, for encouraging and assisting, yes. They
you would have to show a mens rea?
Yes. Right. Yes. So the behaviour which has to be proved is virtually certain to be identical to a criminal offence. The existence of such an order creates stigma. Lord Steyn said that in McCann. It undoubtedly creates stigma, and in my submission, that was in relation to an ASBO, there is still more stigma because of the concept of a gang. And can I just give you very briefly three references in relation to that, and there may be one more, which yes. First is the Amnesty report, Trapped in the Matrix, Secrecy, Stigma and Bias in the Met's Gang Database, 3428. And Mr. Manning says in his skeleton argument there's no evidence that being subject to a gang's injunction or suspected of being a member of a gang creates stigma in the workplace. There is what Judge Wall said about the unexplained failure of the claimant to get his football coaching order, and there's a case study in the Amnesty report 3454, which is precisely this: a man who was perceived to still be in a gang. His mother was sent something saying he's hanging out with gangs, and actually he was at Cambridge. But he then couldn't stay at his halls in Cambridge because he was being told he had to come back to report to somebody. So there are stigma impacts. Also, the recent 2021 Justice report, if I could ask you to look at pages 3516 to 3518, and that cites at 3520 Crown Prosecution Service guidance, which identifies the negative connotations of the term gang and the fact that this label, particularly in the gangs matrix, disproportionately affects people from minority ethnic groups. And the reason, as Broadfoot says, what does this prove? No one's suggesting Judge Wall applied racial prejudices to her judgment here, but the reason is the same as the reason that the competence of the community in the law matters. The competence of this aspect, this section of the community in the law matters too. There is a stigma to a gang's injunction. It makes the consequences of being subject to one particularly
Are these proceedings for these injunctions, they're open to the public, are they?
I've seen nothing to suggest that they're not.
No.
So
there could be publicity given that someone is subject to a gang, one of these injunctions.
There could be, and my lord, I'll come back to it, but the automatic provisions that assume that there will be secrecy in the names of proceedings that relate to children do not apply here. The court can make a decision on it. I think they may be in my table, but I'll come back to that if I may. If I may I steal 5 minutes from my reply just to finish my submissions in chief? That would be...
Yes.
So there is a stigma. The limitations and obligations which can be imposed are wider and more serious and more significant breaches of civil liberties than those under an ASBO. And in McCann, at 595, you see Mr. Crowe, record of Mr. Crowe's... Mr. Crowe for the Secretary of State submitting that one factor pointing away from an ASBO being a criminal penalty was that Section 1.4 of the Act precluded any order being made other than a prohibition. And the record of the argument at 606D is the court cannot deprive a person of his liberty under the cloak of an antisocial behaviour order. It's true that you can't commit somebody to prison or youth detention under the making of a gangs injunction, but you can keep them under a curfew enforced by a tag, which is at least a restriction on liberty. You can make them show up for activities of a certain kind. So that's a distinction which makes this a more serious context than an ASBO. And the infringement of autonomy and Article 8 rights is at least as great, if not greater, in relation to a gangs injunction than an ASBO. So the guarantees recognised as necessary in McCann apply equally or more in this context. The Court of Appeal noted at 179 of the bundle, paragraph 55, that the maximum length of an order, an ASBO under the 1998 Act, was longer than the maximum length of an injunction under the Policing and Crime Act, 5 years to 2 years, and same with the Antisocial Behaviour Crime and Policing Act 2014. That's true, but it's irrelevant because the House of Lords in McCann decided that the fairness standard required the criminal standard of proof to be applied to factual findings necessary for making an ASBO of any duration, and in any event, an ASBO of 2 years or an injunction of 2 years or a gang injunction of 2 years is highly restrictive, especially bearing in mind that an interim injunction could precede it and go straight on. And unlike an ASBO, this can be backed by an immediate power of arrest, which can result in immediate detention. And unlike an ASBO, at least original ASBO, there's an elaborate enforcement regime for minors, which can involve penalties for breach, including up to 3 months of youth detention. It is that combination of circumstances that means that the index findings to be made to the criminal standard, which mean that fairness requires that the findings of fact to be made to justify the making of a gangs injunction should be made to the criminal standard, that is, so that the judge is sure that the facts have occurred, and that's a necessary safeguard to the fair determination of whether or not to grant an injunction as required by Article 6 in this context. I'm going to turn very briefly to the amended provisions concerning antisocial behaviour injunctions, and I take these more briefly, partly because the injunctions made in this case were made under the gangs injunctions provisions, as my Lord Reid observed earlier on, and also because the structure of the 2014 Act is very similar to the structure of the 2009 Act, except that an ASBE can be brought against a child as young as 10, and as Lord Justice Moore-Bick observed at paragraph 13, 2543, the facts that must be established are different and less serious than those to support a gang injunction. But I also submit that it would be possible for declarations of incompatibility to be made in relation to ASBEs and not into gang injunctions. My primary submission is you should make declarations of incompatibility in relation to both. But it would be possible for this to be fair in relation to gang injunctions, not ASBEs, partly because the mischief which an ASBE is aimed at is so significantly more similar to the mischief under the Crime and Disorder Act 1998 than a gang injunction. So one might say the gang injunction is aimed at a wider or a more serious and limited form of antisocial behaviour. Secondly,
That would point in the other direction. Sorry, just to be clear, you're saying that it could, that the...
My lady, you're right. In some ways, it could be in the other direction because the consequences of an as-B are actually very serious too. And I take your point that the stigma and seriousness of the allegations being made are more serious than the gangs injunction.
No, I'm not making any point. I'm just checking that you didn't misspeak when you put it the other way.
It could go either way, actually, my lady. You're right. It could be that that is sufficiently more serious that a higher standard should be applied in the context of a gangs injunction, or it might be said that the mischief, the social mischief, which is being protected against in the gangs injunction is significantly more serious, and the behaviour which it's intended to be stopped under an as-B is so very similar to the behaviour that's intended to be similar to be stopped under an as-Bo that McCann is more binding, more persuasive in relation to an as-B than an as-Bo. But it could go either way, and my primary submission is that this area of the law encompasses both sets of provisions, and fairness demands the criminal standard to be applied in both. But I say it's difficult to explain. And then the second point is the 2014 Act provides for the making of almost identical orders to ASBEs to prevent future antisocial behaviour after a criminal conviction, which is called a criminal behaviour order. But in that context, and without any explanation, the past acts of antisocial behaviour which must be proved, which may not be the same as the elements of the criminal offence for which the conviction has been made, must be proved to the criminal standard. And it is difficult to see or to explain why fairness requires the facts to be proved to the criminal standard in relation to a post-conviction ASB, called a criminal behaviour order, but not a pre-conviction ASB.
So that's section, sorry.
It was my Lord, section 22 of the 2014 Act at the relevant time.
But that's the one we haven't.
But yeah, it's section 22 of the Criminal Behaviour Act. Of the 2009. Section 22 of the 2014 Act,
right,
which is on page 574, but those provisions have now been transposed to the Sentencing Act 2020, page 1648 and following.
thank you.
It was section 22 of the 2014 Act.
Yes, it was, my Lord.
Thank you.
Yes. And although the structure's changed, the effect of the provisions is the same. There's a criminal offence which must be proved. Then the fact of harm must be proved. It's a lower standard than necessity. That's the only other difference between the two. So perhaps I ought to just take you to the. If I can just take you for convenience and because it's shorter to the page 574. Yes, so 574, this is a criminal behaviour order. This section applies where a person is convicted of an offence, any offence. Subsection 2, the court may make a criminal behaviour order against the offender if the conditions are met. The first condition is that the court is satisfied beyond reasonable doubt that the offender has engaged in behaviour that caused or was likely to cause harassment, alarm or distress to any person. The second condition is that the court considers that making the order will help in preventing the offender from engaging in such behaviour.
So it's a lower test than necessity.
Yes, it's a lower test than necessity, but the first condition, the facts, must be proved to the criminal standard.
The second condition is just and convenience, not necessity. Isn't it? Under section 1, page 539.
Well, 574, my lord. Yes, will help.
Yeah.
Yes, will help. It is a lower standard, but it will help.
But the standard for an injunction is just and convenient. and this one is it will help.
For NASB, yes.
Yes, but yes. So if you contrast that, that's the yes. So that's what can be made after a criminal offence has been after a criminal offence has been established.
Yes, but I think Lord Stephen's point is I was comparing the necessity test of the 2009 Act with the will help of the 2014 Act, and he's pointing out that Section 1 of the 2014 Act didn't have a high test of necessity, but a just and convenient test.
Yes. My Lord, if you turn to page 539, the contrast I was making was with the antisocial behaviour injunctions under the 2014 Act. The court may grant an injunction under this section if a person aged 10 or over, against a person aged 10 or over, if two conditions are met. The first is that the court is satisfied on the balance of probabilities that the respondent has engaged or threatens to engage in antisocial behaviour. And the second, again, is just and convenient. And, my Lord, antisocial behaviour is defined on 541, so far as is relevant to this case, as conduct that has caused or is likely to cause harassment, alarm or distress to any person. So my question is, why is it necessary in the context where you have no prior criminal conviction to establish the facts of nuisance or annoyance only to a civil standard, but if you've got a conviction for anything, those facts, behaviour likely to cause harassment, alarm or distress, must be proved to the higher standard of beyond reasonable doubt?
May it be envisaged that he has been convicted of an offence to that higher standard, and in assessing whether that offence amounts to the first condition, it's consistent with the conviction in subsection 1 that also is assessed in relation to that higher standard.
It might, but it doesn't say that. It doesn't have to be the same offence.
It doesn't have to be, but isn't that what they're envisaging?
Well, my Lord,
I haven't read the explanatory notes that go with this.
Legislative materials or Hansard debates or anything that suggests that.
No.
It had the flavour for me of a Newton hearing standard, because this seems to be part of the general sentencing exercise, and then usually where particular facts have not been the matter of a charge but may be relevant to the sentencing, under the guidance in Newton, they have to be established as part of the sentencing exercise beyond reasonable doubt.
Look at subsection 6. A court may make a criminal behaviour order against the offender only if it's made in addition to a sentence imposed in respect of the offence.
Yes.
So I mean, it's envisaging that the offence in question, or it goes and say a discharge, but the behaviour in question has to be proved beyond reasonable doubt, and perhaps reasonably the assessment whether that behaviour was likely to cause harassment and alarm is proved to the same standard.
Well, my Lord, perhaps, but for example, to take this case, there might be a conviction for affray, and affray, it's no part of the finding of an offensive affray that it's caused harassment, alarm or distress to particular people. Now, why is it that if you've been convicted of affray and you're in your criminal court with your post-hearing sentence having been made, whether or not to make this additional civil order has to, the fact of the potential effect on others has to be proved to a criminal standard, whereas if you have no prior conviction, fairness demands that it's determined only to the civil standard. And I say that if you can reasonably and fairly get your order with the facts proved to a criminal standard in the context of a criminal behaviour order, it's strange and illogical to say that you should prove those same facts which had been proved and as bows had been made on quite a large number of occasions since the criminal standard was applied by McCann, that you should make the civil standard that applies to ordinary housing injunctions under section 2, 1b or c.
But you accept that the power in 22 wherever it is now in the 2015 Act, that is part of the sentencing for the offence, an offence in subsection 1.
My lady, I'm not sure.
The conduct, it can't just be that they've previously been convicted of
Well, there is,
something.
I think section 23 is worth looking at in this context. Subsections 1 and 2 and 3.
Yes. Yes, my lord. I'm sorry. I've rushed rather a lot, and it doesn't matter whether the evidence would have been admissible in the proceedings. So you can use hearsay again, and
you can have a further hearing, further evidence, and that evidence can include hearsay evidence.
Yes. So it's a civil order. Yes, it is right that it can only be made by the court that's sentencing, and only if a sentence has been passed.
And only on the application of the prosecutor.
Yes. Nonetheless, it's a civil order made using that broader form of evidence, but still has to be proved to the criminal standard.
I just wonder whether it is a civil order. But it matters not really, because even if it's criminal, you say there's still a contrast between the section 1.
Yes, and that contrast is different from the contrast, just to be clear, that because we only seek a declaration of incompatibility in relation to section 1.2 on page 539, to the extent that it applies to the behaviour in section 2.1a of the 2014 Act on page 541. Because section 2.1b and c are about a much lower level of behaviour, conduct capable of causing nuisance or annoyance. Those are the housing injunctions that were in the 1996 Act. The kinds of orders that can be made are much narrower, and it's altogether. We don't suggest that McCann standard that applied to as-Bos needed to be applied in fairness to as-Bs when they are made in the housing context. It's the fact that the provisions of sections 152 and 153 A to D of the Housing Act had been squashed together with the ASBO provisions and the civil standard applied. The problem has been the application of the civil standard to the ASBO-like behaviour, which is conduct likely to cause harassment, alarm or distress. And I'm asked, thank you, to read section 30 of the Act. It's page 587. Yes, sorry, I ought to have mentioned that. That breach of a criminal behaviour order is an offence, as was breach of an ASBO. Well, I had that in mind. I had a provision that said it, but yes, so that's another distinction, that breach of a criminal behaviour order is a criminal offence, as breach of an ASBO was, but I remind you that breach of an ASBO had to be proved to the criminal standard.
And wasn't there some background material to the effect that it was thought that because of McCann, if the breach of a criminal behaviour order was an offence itself, then you had to apply the criminal standard of proof? Wasn't that the sort of background thinking to it? The
breach always has to be proved to criminal standard. I mean,
but the difference between a Section 1 injunction and an ASBO is that it's civil contempt, you don't get a criminal record.
Yes.
And whereas a breach of this order would be a criminal offence, and you would get a criminal record for breaching this order. And it was thought that in such circumstances, because of McCann, or the thinking of McCann, that a breach of a criminal behaviour order, a criminal behaviour order had to be established beyond all reasonable doubt. I thought that was the underlying reason for the difference between the two.
Yes, my lord, the point I'm making is that the seriousness of the sanction in practical terms for the civil breach, especially for the civil breach, can include incarceration as well. So, and it has to be proved for criminal standard. But you're right, it doesn't. There is a point of distinction, and it doesn't result in a criminal record. And you're right that that was the government's thinking about distinguishing between criminal behaviour order and an antisocial behaviour injunction.
Just to be quite clear, the provisions you've taken us to lately in Part 2 of the 2014 Act have all been repealed, haven't they? According to Westlaw, at any rate.
So it's Section 22, yes, they've been replaced, my Lord. They've been put into the Sentencing Act 2020. Oh. I took you to those because those are the ones that were enforced at the relevant time, but they are, it's in my skeleton argument where they are. They're in Section 20. They're in the Sentencing Act 2020.
So they've effectively been reenacted, have they?
The structure's sufficient. I can show you them to you if you want. The structure's sufficiently different, but it's not quite a reenactment, but the effect is the same, my Lord. Right. Yeah, they've
I think you gave a page reference of 648.
Or it did.
Yes, thank you. So, my Lord, in summary, I'm conscious that I've eaten into my right of reply time, so that's to be taken as read. But what I say is that the gravity of what is alleged under both these, the 2009 Act and Section 21A of the 2014 Act, the stigma and the draconian consequences on individual civil rights of such orders, bearing in mind the fact that there is a need to protect the public and hearsay can be admitted. But all that taken in combination means it can only be fair to impose such orders for deterrence and public protection if the factual basis for them is established on the criminal standard of proof. That doesn't operate to undermine the statutory scheme, but in my submission to guarantee that it operates fairly and compatibly with the overarching requirement for a fair trial in Article 6.1 of the European Convention on Human Rights. So I ask you to grant the relief that we've set out in the prayer at page 96 of the bundle.
Thank you, Ms. Moutfield. Well, I think we'll adjourn for a few minutes to decide where we've got to and what, if anything, we need to hear you on. Well, Ms. Broadfoot, tomorrow it would be very helpful to us if you could assist us on two issues. The first is any Strasbourg authorities concerning the burden of proof. Burden of proof. I'm sorry, I mean the standard of proof.
Yes, thank you.
Beg your pardon. And secondly, the question whether the case of McCann should be understood as an authority on Article 6.1.
Yes.
And those are the only issues we think we need to hear you on. And once you've addressed us on those, if Mr. Manning would simply be adopting what you have said, then we won't need to hear you, Mr. Manning. Of course, if you have something distinct you want to say on those issues, then we'll hear you. And then hear Ms. Moutfield in reply.
Thank you very much.
Sure. So we'll adjourn now.
Thank you.